The Indian Contract Act 1872, one of the important law which each and every professional student will study in one or the other level of examination. CA students studies this law at the CA foundation level. CS student studies this law at the CS EET level as well as in the CS executive level. CMA student studies this law at the CMA foundation level as well as CMA inter level. The law students studies this law in the first sem of LLB examinations. So let's start with the Indian Contract Act 1872. The Indian Contract Act 1872. The Indian, one of the oldest law, Indian Contract Act. Contract Act. Which year? 1872. 1872. The Indian Contract Act 1872 is divided into four parts. How many parts? Four parts. It has been divided into four parts. Part 1 covers section number 1 to 75. Then part 2 covers section number 76 to 123. Part 3 covers section number 124 to 238, and the part 4 covers section number 239 to 266. So in total there are four parts. Part 1 1 to 75, part 2 76 to 123, part 3 124 to 238, and the part 4 239 to 266. Part 1 of the Indian Contract Act deals with general principles of contract. General principles of what? Of the contracts. So these are the principles which are applicable for every type of contract irrespective of its nature. It is applicable for contract of indemnity, contract of bailment, contract of guarantee, even for the other type of contract, sale of goods contract, partnership contracts. So the principles which are applicable for all types of contracts are called as what? A general principles of contract, and those are covered under section number 1 to 75. Then 76 to 123. Section number 76 to 123 used to deal with contract of sale of goods. Contract of sale of goods. But these provisions which were dealing with the contract of sale of goods were repealed. Now what do you mean by repealed, sir? It means it is removed from the Indian Contract Act. They were removed from which act? The Indian Contract Act 1872. In which year, sir? In the year 1930, and a separate law was made called as what? Sale of Goods Act and 1930. SOGA. So section number 76 to 123 is no more the part of Indian Contract Act 1872. So section number 76 to 123 are not there in the Indian Contract Act 1872. Then section number 124 to 238 deals with a special contracts. So what are the special contracts we have, sir? The first one is contract of indemnity. Contract of indemnity. Section number 124 and 125 deals with contract of indemnity. Second one, contract of guarantee or surety. Then third one, contract of bailment. Contract of bailment. Fourth one, contract of pledge. Contract of pledge. And the fifth one, contract of agency. Contract of agency. So these are the 5 types of special contracts which are covered under section number 124 to 238. Then section number 239 to 266. These section numbers were dealing with a contract of partnership. Contract of what? Partnership. Section number 239 to 266 were dealing with the contract of partnership, and these provisions were repealed, means removed from which act? The Indian Contract Act 1872, and a separate law was made. What is the separate law they have made, sir? Called as the Indian Partnership Act. Indian Partnership Act 1932. So 239 to 266 is no more the part of Indian Contract Act 1872. So at present, We have section number 1 to 75, which deals with general principles of contract, and 124 to 238, which deals with special contract. That is contract of indemnity, contract of guarantee, contract of bailment, contract of pledge, and contract of agency. So let's start with section number 1. Section number 1. Section 1 in any act, it can be Contract Act or Sale of Goods Act, or it can be Companies Act or IPC, CPC, CRPC. All these laws, section number 1 deals with or provides 3 provisions. Section number 1 provides how many provisions? 3 provisions. Now the 3 provisions are, section number 1 provides the 3 provisions. The first one is what? Short title. What title? A short title. Second one is the extent to which the law is applicable. Third one is the commencement, the date on which the law came into force. So what is the first provision? Short title. What is the short title of the Indian Contract Act, sir? Nothing but the name of the act. The Indian Contract Act. Indian Contract Act. Which year? 1872. Extent. This law is applicable to whom? All of India. Sir, are there any exceptions, sir? No, sir, there are no exception. Why? Because all the laws made in India are applicable even to where? Jammu and Kashmir. Because Article 370 is no more the part of Constitution of India. So all the laws made in the Indian Parliament is applicable even to the Union Territory of Jammu and Kashmir. Why? Because Jammu is not no more a state. It is a Union Territory. So this law is applicable to whom? The whole of India. Commencement. This law came into force on the 1st September 1870. Section number 1 provides how many provisions? 3 provisions. What are they? Short title, extent, commencement. What is the short title? The Indian Contract Act 1872. Extent, the whole of India. Commencement, the 1st September 1872. This is section number 1. Section number 2. Section 2 is called as definition section or interpretation clause. What clause? Interpretation clause. Keep this in mind. Section number 2 is always called as what? A definition sections or interpretation clause. What is interpretation, sir? Understanding, the correct understanding of the law. Interpretation clause, which provides the definition of various words used in the law. If you want to find the meaning of agreement, where do you search? Section number 2. In case of Companies Act, if you want to search the meaning of company or director, where do you search? Section number 2 of the Companies Act. In Sale of Goods Act, if you want to know who is the seller or who is the buyer, where do you search? Section number 2 of the Sale of Goods Act. Because section number 2 is the definition clause or interpretations clause. Clear? So we'll discuss the definition of the various words with the concept wherever the concept comes. Done? Yes. Now let's discuss the concept of what is contract or how the contracts are made in India. Done? Yes. So every contract starts with offer. Starts with what? Offer. So the initial part or the starting part of the contract is what? Offer. So offer plus acceptance. Offer plus acceptance becomes what? Becomes a promise. Becomes a promise. Then promise plus consideration. Promise plus consideration. A promise having the consideration becomes what? Becomes an agreement. Becomes an agreement. Then agreement plus enforceable by law. Agreement plus, if it is enforceable by whom? By the law, becomes what? Becomes a contract. This is how what is made? The contracts are made. What is the first step? Offer. Offer plus acceptance becomes what? Promise. Promise plus consideration becomes what? Agreement. Agreement plus enforceable by law becomes what? Becomes the contract. So let's take an example. With the example, understand the concept of what is offer, acceptance, promise, consideration, agreement, and enforceability of law. Let's say there are two parties. Okay, let's say we have Virat. There is one person by name called as Virat, and there is another person by name called as whom? Name called as Anushka. Anushka. Okay, so there are two individuals here. One is Virat, another one is Anushka. Now Virat want to sell his car. He has a car, or let's say he has some goods. So now what Virat does, he makes an offer. Who makes an offer? Virat makes an offer to sell the goods. Sell the goods to whom? To the Anushka. Now, after thinking over about the offer, what she does, she gives the acceptance. Acceptance to whom? To the offer of the uh, Virat to purchase the goods at what price? Let's say at 2 lakh rupees. So 2 lakh is the price at which Virat made the offer to sell his goods. So who made an offer here? Virat made an offer to sell his goods to Anushka at what price? 2 lakh rupees. And who gave acceptance for this? Anushka gave the acceptance for this. Clear? So after some time, what happened? Virat delivered the goods. The third incident is the Virat, what he has done? He has delivered the goods to Anushka, who has agreed to make the payment after some time. Third event is who delivered the goods? Virat delivered the goods to Anushka. Now, who is bound to make the payment? Anushka is bound to make the payment because she made a promise to pay 2 lakh rupees. But now, what Anushka does? She refused to make the payment. Who refused to pay? Anushka refused to pay, means she failed to keep her promise. Now, the question is, what is the legal remedy available to Virat? What is the legal remedy? What is the legal remedy available to whom? Available to Virat. Can he go to the court? If he go to the court, will he succeed in the recovery of 2 lakh? All these questions, the answer to all these questions depends upon what? Whether there is a valid contract between Virat or Anushka. Because only a valid contract creates a right and obligation between the parties to a contract. If there is a valid contract, it means there is Virat has the right. If he has the right, the court will enforce the right of Virat and compel the Anushka to pay the agreed amount of 2 lakh. So let us discuss one by one. So to be a contract, what is the first step? There must be an offer. There must be what? Offer. Now what is offer, sir? Offer means section number 2, subclause A defines the word what? Offer. So what is offer, sir? Offer means when one person, how many person? One person signifies. One person, what he does? He signifies. He signifies. Signifies what? His willingness to do. Signifies what? So what is the first step? So let us discuss whether there is a valid contract between Virat and Anushka. If there is a valid contract, who will succeed? Virat will succeed. To be a valid contract, what is the first step? There should be an offer. Was there any offer? Yes. Virat made an offer to sell his what? Goods. At what price? 2 lakh rupees. So there is an offer. Then what is the second step? There must be an acceptance. So who should give an acceptance here? Other party. So was there any acceptance in this case? Yes, Anushka gave an acceptance to purchase the goods at what price? 2 lakh rupees. So there was an acceptance. There was an offer plus there was an acceptance. So when offer is accepted, becomes what? Promise. So there are how many promise here? Two promise. How many promises are there? Two promises. Two promises. Who are the promisers here? There are two promises. Promise number one. What is the promise number one? Promise number one is, what is the promise number one? Promise number one is to what? Is to deliver the goods. Promise number one is to what? Deliver the goods. So promise number one is to deliver the goods. Deliver the goods. So who made a promise to deliver the goods here? Virat made a promise. Virat is the promiser. Virat is the promiser. And there is a promise number two. What is promise number two? Promise number two is the payment of price. Payment of price. Price of how much? 2 lakh. And for this, who is the promiser? The promiser is Anushka. Promisor is Anushka. Now, as per the law, there must be a consideration for every promise. If there is no consideration for a promise, then it is not consideration agreement. If it is not consideration agreement, it will not become a contract. So, is there any consideration for the promise of Virat, sir? Yes. Now, what the other person is doing at the desire of Virat. Keep this in mind to be a consideration, to be a valid consideration. The consideration must happen at the desire of whom? Desire of promiser. At the desire of the promiser, what Anushka is doing, the Anushka agreed to pay. Agreed to pay how much? She has agreed to pay 2 lakh rupees. So this is the consideration for whom? Consideration for Virat. Now, what is consideration, sir? When at the desire of the promiser. In our example, who is the promiser for the promise number 1? Virat. At the desire of the promiser, promisee or any other person either does something or has done something or abstain from doing something or promises to do something. Such an act, abstinence or a promise is called as what? Consideration. So to be a valid consideration, keep this in mind. The fundamental rule of consideration is that consideration must always happen. Whose desire? Promiser desire. Who is the promiser? Virat. At the desire of promiser, who is paying the money here? Anushka is paying the money. How much she is paying? 2 lakh. As per whose desire? Virat desire. That is the consideration for whose promise? Virat promise. So there is a consideration for Virat promise. Second promise. Who is the promiser? Anushka. So at the desire of Anushka, who is giving the goods? The promisee. The Virat is giving the goods. Virat is giving the goods. Now, this is the consideration for whom? Consideration for Anushka. Because Virat is giving what the goods Anushka wants, not whatever he wants. It means he is doing something at whose desire? Anushka's desire. That is considered as consideration for Anushka's promise. So, promise plus consideration. Every promise having consideration becomes what? Agreement. I repeat, offer plus acceptance becomes the promise. Promise plus consideration becomes the agreement. Agreement, if it is enforceable by law, becomes what? Contract. Now the question is, when can we say an agreement is enforceable by law and when can we say an agreement is not enforceable by law? So to be enforceable by law, there are few conditions to be satisfied. To be enforceable by law, section number 10 of the Indian Contract Act provides the essentials to be satisfied to be a valid contract or to be enforceable by law. What are these? Are the conditions are the fish can laugh. If the fish can laugh at night, at what time? 10 p.m. Fish can laugh at what time? Night time. Night time 10 p.m. Then the agreement is enforceable by law. Otherwise, the agreement is not enforceable by law. So what are these? Fish may we should take into consideration F. In the can C, then in the L laugh L, and in the night we should take into consideration N. So what is F, sir? F means a free consent. What consent? A free consent. F means the free consent. C means competent to contract. Competent to contracts. The parties must be competent to contract. Then L means lawful object. What object? Lawful object, and consideration should be there in a contract. And the last one, N. N means what? Not expressly declared as void. Not expressly declared as what? Void. So these are the 4 fundamental conditions to be satisfied to be a valid contract. What are they? Free consent, competent to contract, lawful object and consideration, and not expressly declared as void. Section 10 clearly provides that all agreements are contract if they are made with what consent? Free consent. By which party? Competent party. For what object? Lawful object and consideration, and which is not expressly declared under the Indian Contract Act 1872. I repeat, all agreements are contracts if they are made with a free consent by a person who is competent to contract for lawful object and consideration, which is not expressly declared as void. So do our agreement satisfy all this? Sorry, not our agreement. Virat and Anushka's agreement satisfy all these conditions. Let's check. Was there any offer? Yes, sir. But there was an offer. Was there any acceptance? Yes, sir. There was an acceptance. So offer plus acceptance becomes what? Promise. They have a valid promise now. So for this promise, was there any consideration, sir? Yes. Both the parties has done something in return to the other person at the desire of the promiser. So it is an agreement now, and agreement must be enforceable by law. What are the conditions? First one, free consent. Was the consent of the party free? Yes. There was no coercion, undue influence, fraud, misrepresentation, mistake. So the consent was what? Free. Second one, are the parties competent to contract, sir? Yes, the parties are competent to contract. Both are majors, sound mind, and not disqualified by law. Then next one, lawful object and consideration. What they are agreeing to sell? Goods. Is selling goods in India is lawful? Absolutely, it is lawful. So then there is a lawful object and consideration, and nowhere in the Indian Contract Act selling of goods is prohibited by law or declared as void in the Indian Contract Act. Hence, it is not expressly declared as void. It means it is enforceable by law. So, the Virat has a legal remedy of approaching the court, and the court will assist him in recovery of 2 lakh rupees from Anushka because the agreement is enforceable by law. So, this is how the contracts are made in India. I repeat, offer plus acceptance becomes a promise. Promise plus consideration becomes an agreement. Agreement plus enforceable by law becomes a contract. There are 4 conditions of enforceability. Fish can laugh at night. F means free consent. C means competent to contract. L means lawful object and consideration. And N means not expressly declared as void. So how to remember the sections of these words, sir? For example, first one. What is the first word? Offer. Section 2, subclause A defines the word offer. I will discuss the definition of offer later. But I'll give a fair idea of what is offer. Offer means when one person signifies his willingness to do, that is to do something, or abstain from doing anything or something with the intent to obtain the assent of the other person to such an act or an abstinence is said to make a proposal or offer. So offer can be positive as well as negative. So in our equation, the first one is offer, and in the alphabets, the first letter is A. So section number 2, subclause A defines the word what? Offer. Then second step is what? Acceptance. So 2B defines the word what? Acceptance. So what is acceptance, sir? When the person to whom the offer is made signifies. What do you mean by signify, sir? Express is assent to the offer. It is called as an acceptance. So offer plus acceptance becomes what? Promise. And promise plus consideration becomes what? Agreement. So section number 2, subclause C defines the word promiser and promisee. Who is promiser? The one who makes the promise is called as what? Called as the promiser. What happened to this? One second. So, yes. So the one who makes the promise is called as what? Promiser, and the other person is called as what? Promisee. Correct, right? Yes. Now there should be a consideration for every promise. Correct, right? No consideration, no promise or no contract. Section number 2, subclause D defines the word what? Consideration. So what is consideration? As I said, the fundamental rule of consideration is that the consideration must happen at the desire of the promiser. So when at the desire of the promiser, promisee or any other person either does something or has done something or abstain from doing something or promises to do something, such an act, abstinence or a promise is called as consideration. So consideration can be a positive act, negative act, it can be a suffering, it can be an inconvenience caused by the one party at the desire of the other party. So promise plus consideration becomes agreement. So section number 2, subclause E defines the word agreement. So what is agreement? Every promise or set of promise having consideration for each other are called as what? Consideration. Sorry, agreement. I repeat, every promise or set of promise having the consideration for each other are called as what? Agreement. And the agreement which is enforceable by law, that means 4 conditions, becomes what? contract. Section number 2, subclause H defines the word contract. 2A, offer. 2B, acceptance. 2C, promisor and promisee. 2D, consideration. 2E, agreement. And 2H is contract. So what is contract? Agreement enforceable by law is called as contract. What is agreement? Every promise or set of promise having consideration for each other is called as agreement. And what is promise? An accepted offer becomes what? Promise. And what is acceptance? When the person to whom the offer is made signifies his assent to the offer, it is called as acceptance. And what is offer? When one person signifies his willingness to do or abstain from doing anything with the intent to obtain the assent of the other person to such an act or an abstinence is said to make a proposal. So this is the equation for understanding the how the contracts are made in India. I hope you guys are clear with these concepts. So let's discuss the next concept. Next concept. What is the next concept, sir? The next concept is the essential elements of an valid contract. The essential elements are valid contract. A valid contract. So what are the essential elements of valid contract? I have already discussed the 4 essential elements which are given in the which act itself, which are given in the Indian Contract Act itself. That is, fish can laugh at what time? Night time. What is F? A free consent. What consent? A free consent. Second one, competent to contract. Competent to contract. Third one, lawful object and consideration. And the last one, not expressly declared as void. It should not be declared as void by the Indian contract. So along with 4 conditions, there are 5 more conditions which are based on interpretation. Now what is interpretation, sir? Understanding of the correct understanding of the law. The courts through various judgments have discovered few more principles which are required to be satisfied to be a valid contract. So there are 5 more extra conditions or essentials which are also required to be satisfied to be what contract? A valid contract. What are they, sir? First one, there must be intention to create what relationship? Intention to create a legal relationship. Create a legal relationship. Second one, there must be minimum how many parties? 2 parties. 2 parties. Third one, must satisfy other legal formalities. If there is any specific law which provides the legal formalities to be complied with, even those legal formalities to be complied with. Fourth one, it has to be possible to perform. Agreement must be possible to perform. Impossible to perform, not enforceable by law. And the fifth one is meaning must be certain. Must be certain. Nothing but the terms and conditions of the agreement must be certain and clear. So these are the 5 essentials which are to be satisfied along with the 4 essential elements which are given in the Indian Contract Act 1872 under section number. What is the first one? There must be intention to create what relationship? A legal relationship. And for these we have a case study. What is the case study name we have? Mrs. Balfour. Mrs. Balfour versus Mr. Balfour. And for the 2 parties we have a case study. What is the case name? We have a case by the name called as ITO. Income Tax Officer versus whom? Versus the Raman Lal and Co. Raman Lal and Co. So these are the 2 case laws which we are supposed to study. So let us discuss these essential elements of an valid contract with the help of the material in detail.